Alright guys, here's state number 4, Arkansas. I've broken the analysis down into 9 different categories as usual. You can check the description for timestamps if you want to kind of skip around, but I'm going to try to keep it all brief enough to where it's easy to sit through the whole thing. At the end, I'll be giving the state a grade. If you like this sort of content, do me a favor and like the video and subscribe, hit the bell, whatever. It lets me know what kind of content to focus on. It's also a really nice thing to do that I really appreciate.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
Right on, so let's take a quick look at Arkansas's state constitutional right to arms, and let's keep it in mind as we go through the rest of the video. Article 2, Section 5 of the Arkansas Constitution states that the citizens of this state shall have the right to keep and bear arms for their common defense. Now, one might think that this sounds as good as many high-ranking states, but in actuality, this is written weaker than the federal Second Amendment. For one, the limitation to citizens of the state is an odd sentence making the right subservient to a presumably state-level categorization. Further, it limits the arms to their common defense. Were this sentence in the federal Second Amendment, it would have been a field day for those who was arguing that there was no individual right to arms. To go with all of that, the Supreme Court of Arkansas has taken incredible pains to reject state constitutional challenges to gun regulations. Most recently, the 1993 case of Jones v. Little Rock saw the Supreme Court of Arkansas state, even though nobody brought up the state right to arms at all, that long ago we made it clear that the state may place restrictions on one's right to bear arms consistent with the state constitution. To go over what the state Supreme Court has okayed against challenges, in 1872, 76, and 82, the court upheld prohibitions on concealed carry and a ban on pocket pistols in 1882. On the other hand, the state Supreme Court did overturn a ban on the open carrying of war arms in 1878, calling it an unwarranted restriction on the man's constitutional right to keep and bear arms. Still, a rather mayonnaise-spicy state constitutional right to keep and bear arms, if you ask me. So now let's talk about restrictions on owning firearms. This is, if you ask me, the most pernicious class of gun restrictions. These are prerequisites on owning a firearm at all. This section will be limited to run-of-the-mill pedestrian firearms like handguns, shotguns, and rifles. State restrictions on NATO guns that the feds like to regulate independently will be in the cool gun restriction section. To start with, Arkansas has no law requiring gun owners or buyers to get a special license and no law requiring the registration of firearms. As for minimum age, there is no minimum age to possess rifles and shotguns in Arkansas. That said, the state generally prohibits anyone under 18 from possessing a handgun outside of private property, with some exceptions. As far as getting them, anyone who furnishes a firearm to someone under 18 without the consent of their guardian is liable for a misdemeanor if it's a rifle or shotgun, and a felony if it's a handgun. As we know, federal law prohibits a wide range of nonviolent felony and misdemeanor offenders from ever owning firearms at all, but being that most criminal prosecutions are on the state level, state policy can make a huge difference for people who spend their lives in a certain state. On this, Arkansas follows federal law fairly closely. The state prohibits anyone from possessing a firearm if they have been convicted of a felony, unless it's one of those fancy business felonies, if they've been adjudicated mentally ill, or if they've been involuntarily committed to a mental institution. As for those adjudicated mentally ill, federal law does not require states to report these individuals to the NICS system. However, Arkansas does require that courts report these people to the Arkansas Crime Information Center, which then reports it to NICS. Further, anyone arrested, not convicted, but arrested for trafficking persons, kidnapping, first-degree false imprisonment, or an offense that involves taking a minor without consent cannot be granted bail unless they agree to relinquish firearms for the duration of any no-contact orders. The judge can waive these conditions if doing so would not result in an increased risk to the community or an increased risk of flight by the accused. Compared to many other states, it's worth noting that Arkansas does not prohibit those convicted of misdemeanors from possessing firearms, nor does it prohibit those subject to domestic violence restraining orders from having them. The state does, however, require courts to notify anyone convicted of such a misdemeanor that it is unlawful for them to continue to possess firearms under federal law. That said, Arkansas generally also has no law requiring the removal of firearms from those who have become prohibited from possessing them, except for those instances we mentioned earlier. All in all, this being the fourth go, it's worth noting that Arkansas treatment of the simple ownership of common firearms stands out as particularly liberal. Now onto restrictions on the actual purchase, buying, and selling of arms. This section is for laws that restrict how an individual can acquire a firearm. While federal law controls FFLs, it does not control how individuals inside a state can transact privately with firearms. This leaves a lot of opportunity for states to either respect or severely frustrate the rights of their residents. Arkansas has no independent requirements that dealers or private sellers conduct a background check on gun buyers, and no state requirement that gun dealers be licensed. It is worth noting that federal law exempts buyers from background checks if they have state firearms permits that meet certain conditions. As a result, Arkansas carry permit holders are exempt from handgun background checks. As far as FFLs go, Arkansas is not a point of contact state for the NICS background check, and thus FFLs within the state go through the FBI directly, rather than having a grubby state agency add a layer of nonsense to the background check system. Remember, things like buying guns at gun shows and private sales are not loopholes, they are a natural result of our system of dual federalism, where the federal government is supposed to lack the power to touch purely intrastate transactions. All that said, Arkansas does prohibit transferring a firearm to anyone that you know to be prohibited under state or federal law as a misdemeanor, unless it's a handgun, in which case it's a felony. The state has no law requiring gun dealers to keep records of sales or background checks by sellers of firearms generally, and no state-level laws regulating gun shows, and no waiting periods. All in all, a fairly strong section for the state. Now let's get on to homemade guns. As we've discussed here many times, the right to keep and to bear something necessarily includes the right to acquire it, and the purest way to acquire something is to make it yourself. That's why it is certainly a point in Arkansas' favor that it has no law restricting homemade, 3D printed, or otherwise lawfully made unserialized firearms. It does, however, prohibit possession of a firearm with a obliterated serial number. Another obvious prerequisite to a real right to keep and bear arms is the ability to feed them. After all, how can we turn money into noise without an ample supply of gatteries? Arkansas has no laws requiring a license for the sale of ammunition, nor does it require sellers to keep records of ammunition purchasers, nor does it independently prohibit those prohibited from possessing firearms from possessing ammunitions, nor does it prohibit armor-piercing ammunition. Not too bad here either. Now on to carry. Of course, to keep and bear arms includes bearing them. This being something states continue to slam their heads against repeatedly and with great force. Until 2021, Arkansas required a permit to carry a concealed firearm in public, but that was chucked in the trash quite recently. Still, the state maintains its permitting statute for reciprocity and other purposes. As far as the permit goes, it is a shall issue state, which more than its fair share of twists and turns. To get a concealed carry permit, you must be a U.S. citizen or lawful permanent resident, a resident of Arkansas for 90 days or more, be 21 years of age or more antique, not be mentally busted, or attempt to off yourself. You must also not be a felon unless you were pardoned with rights restored, not be prohibited from possessing a firearm, and you have to pass 2 whole background checks. You must not use so many drugs that you don't know where you are or what things are generally, and not use so much booze that you are similarly non-functional. You must also desire a legal means to carry a handgun. You must not have been involuntarily or voluntarily committed to a mental health facility, and you must not be a fugitive. You must do your little training class, and finally, you must sign a statement of allegiance to the constitutions of the United States and the state of Arkansas. The Grand Master of Permits may deny your license if within 5 years you did a domestic violence, if you were found guilty of carrying a weapon, or if a local cop writes him a letter saying that he does not like you. The Permit Master has 120 days to review the completed applications. If state police get notification that a licensee has been convicted or pled no contest to any crime involving the use of a weapon, the license is immediately revoked. In addition, the permit master must revoke the license of anyone guilty of an alcohol-related offense committed while carrying a handgun. Finally, he may revoke a license if the licensee was found guilty of one or more crimes of violence in the preceding 3 years. As for the training, anyone registered with the state police as a firearms instructor can provide it. The state does not mandate the specifics of the training, just that the participant demonstrate a basic level of knowledge, understanding, and practical operation for safe handling of a handgun. The state does have a kind of enhanced permit where carry permit holders can take a training course approved by the cops to obtain a carry endorsement, which lets you carry in places that would otherwise be restricted, such as university buildings and the state capitol. The law specifies that this training must be offered at no more than a nominal cost. At the time of this recording, I was able to find it for about $100, and the price of a basic permit looking to be around $90 if you're under 65. Carry permits are valid for 5 years, with renewals coming with a $35 fee, a new background check, photograph, and proof of training. If you don't have this special DLC permit enhancement, you can't carry in cop stations, most state buildings, government meetings, any athletic event, bars, the passenger terminal of an airport, a church without special permission, a parade, or anywhere with a no-gun sign, and other sports fields. Also, bar owners or booze manufacturers can get fined if you carry into their business and someone snitches. The state is required by law to keep an online database of permit holders available to law enforcement at all times. The state has a law preventing disclosure in certain instances, but it's one of the weaker privacy laws that we've seen so far when it comes to carry permit information. Reciprocity, on the other hand, looks fairly good. The state recognizes all out-of-state licenses, regardless of whether the issuing state recognizes an Arkansas license. I also know some of y'all like to let it all hang out. So let's talk about open carry now. Arkansas isn't as straight and narrow here as you might expect. Arkansas law generally bans the carry of a handgun on the person if readily available for use with a purpose to attempt to unlawfully employ it as a weapon against a person. Now, this language is still sitting in the law despite the resolutions to turn Arkansas into a constitutional carry state, quote, with no permit required to carry a handgun, either unconcealed or concealed. When it comes to carrying rifles, though, the law is silent, as it should be. As for schools, Arkansas generally prohibits possessing firearms at all on the property of a K-12 school, on a school bus, or at a designated school bus stop. Arkansas does allow carry permit holders to keep a firearm in their car on K-12 premises, and churches or private organizations that operate K-12 schools, they may allow licensees to carry on property. A 2017 law compels public universities to allow permit holders to carry concealed on university property if they've completed the carry endorsement course that we talked about earlier, that special DLC permit. That same law also allows licensees, whether endorsed or not, to carry concealed on university campuses unless the college has a policy expressly forbidding this and has posted notices to that effect. Colleges that want to restrict guns at certain areas during sporting events can submit a security plan to the state in order to get permission to designate various areas as firearm sensitive. It does remain generally unlawful to store a blaster in a college-operated dorm room or housing facility. As for workplace stuff, property owners and employers are required to allow anyone with a carry permit to keep their firearms in locked vehicles in the parking lot. This is far from the worst in the country, but it is worth noting that there is a ton of contradictory garbage on the books in Arkansas, as we will be seeing more of. It seems to me that the state legislature may be well-intentioned, but for whatever reason is incredibly hesitant to repeal anything. Now onto self-defense. Self-defense is an interesting thing to discuss here in this context, as it's not really specifically gun law, but a closely related and all too constantly shifting area of law. The thing to understand here is that the law was always designed to protect the innocent actor, the reasonable person who did not acquire a dangerous situation of his own actions. Over the years, courts began imposing a duty to retreat whenever somebody was attacked outside of their home. The logic there was that someone who could have possibly escaped a dangerous situation didn't necessarily have to use lethal force. This is, of course, insane because the innocent actor did not choose the situation to begin with and shouldn't be forced to take particular actions to protect themselves. If they had, their hands would be unclean and thus not open to the defense to begin with. To address this, states began passing what are colloquially referred to as stand your ground laws to correct these courtroom cock-ups. Arkansas became one of them in 2021. That's when the state passed a law eliminating the duty to retreat before using deadly force in a public place where they are lawfully present and not doing any crimes at the moment. Arkansas is kind of shockingly late to the party here, if you ask me. Alright, now we're going to talk about cool gun restrictions. Here's where we'll talk about whether the state stacks stuff on top of the NFA and GCA when it comes to those kinds of guns, those short boys, those fast firers that the feds make us pay extra special taxes to own. You might be shocked to hear it, but wow, is Arkansas a cluster here. Before 2019, it was prohibited to possess any bomb, machine gun, sawed-off shotgun or rifle, silencer, brass knuckle, or other implement for the infliction of serious physical injury or death. So basically, for the longest time, NFA stuff was effectively banned in Arkansas. Then around 2019, some Arkansas politic guy endeavored to undo all of that, except he didn't. 2019's Arkansas House Bill 1820 removed machine guns, short boys, and suppressors from the prohibited weapons list, and also removed them from the felony enhancement list that we talked about earlier concerning giving them to, like, kids and stuff. It added a section that says that weapons prohibition does not apply if the possession of the weapon is in compliance with federal law. It also didn't unban brass knuckles. However, there is a separate law, the Arkansas Uniform Machine Gun Act, that imposes certain restrictions on machine gun possession and use. For one, the state defines a machine gun in the most clown shoes way I've seen so far. It goes as follows. A machine gun, according to Arkansas, is a weapon from which more than 5 shots or bullets may be rapidly or automatically or semi-automatically discharged from a magazine by a single function of the firing device. What? So, like, I guess the 4-shot burst Brita PG and unconverted M16A2s fall outside of this, perhaps, I guess, maybe. The law also makes it illegal to possess a machine gun for offensive or aggressive purposes. Now, you might think that's okay, but the main issue here is how that law defines offensive or aggressive purpose. It presumes that you have such a purpose in any of the following situations. 1, if the gun is in any place that is not owned or rented by you, the possessor. 2, when it is possessed or in use by a foreigner or criminal. And 3, when empty or loaded pistol rounds, 30 caliber or larger, which the gun can use, are near to the gun. There is a separate section that says it is not unlawful to possess a machine gun that does not use pistol cartridges larger than 30, and it's possessed for a purpose manifestly not aggressive or offensive. Or if you're an ammunition manufacturer, or of course if you're trying to sell them to the cops. So this 30 caliber handgun ammo thing, it's really confusing because in one part of the law it says pistol cartridges 30 caliber or larger, and then another part of the law it says 30 caliber or larger caliber. I snooped around quite a bit and I couldn't determine for sure whether the law prevents you from possessing machine guns in rifle calibers or if rifle calibers were considered a larger caliber, as the law appears that it was written by a moron. So basically, it's legal to own a machine gun in Arkansas, but the law in the books seems to indicate that you can't shoot it or keep ammo for it unless it's chambered for a round smaller than 30 Luger. This is another example where Arkansas just refuses to chop sections from the law. Instead, they're red penning them and leaving a ton of mess. It's clear that the lawmakers' intent was to bring the state into conformity with federal law, which, hey, why not go better? But instead, he just left a mess. It's a law that says it's legal to have a machine gun, except if it's aggressive. Oh, and by the way, using a machine gun is automatically aggressive, unless it's a .22? Aside from that, there are no restrictions on magazine capacity, caliber, or assaultiness of firearms in Arkansas. All right, let's talk about rights restoration. We've talked a lot about losing rights, but getting them back is just as important. Arkansas allows restoration of firearms rights lost due to a criminal conviction. There is no specific restoration process for persons who are prohibited due to an adjudication or commitment for mental illness. State firearms prohibitions do not apply in the following situations. This meaning you are no longer prohibited on the state level. When your case has been dismissed and sealed or expunged under certain processes, when the person has been granted a specific firearm restoration pardon, and if your conviction was a non-weapon related one and it is more than 8 years old, there is a process that you can get your rights back without a pardon with the recommendation of your local chief law enforcement officer. This is better than nothing, but it's more messy Rube Goldberg stuff that the state is just known for at this point. All right, now let's cover the various and sundries before we get to a grade. Local governments are forbidden from regulating guns in Arkansas except for laws forbidding the unsafe discharge of a firearm. It is unlawful to deface the serial number or identification mark of a firearm or to knowingly possess such a firearm in Arkansas. It is unlawful to shoot from across a public road or right-of-way in the state. Only the state may bring suits against firearm manufacturers or dealers in the state absent special circumstances. There is a 2021 law that allows public schools to offer hunting safety courses as part of a PE curriculum, and the instructor may use an operable firearm as part of his instruction. All right, now let's assess and grade Arkansas. We're going to use our previous states as kind of a guidepost. You know, the state's motto is Regnat Populus, which is Latin for the people rule. No other state has this motto, and it's a shame that the state's law does not respect that symbol. Going into this episode, I remember reading lots of things about Arkansas being ranked extremely highly for gun rights. I also know that some of my favorite gun companies chose to move there. Digging into the law, though, I just don't see it. Most of the stuff that is any good has come recently, and those recent changes to the law have been universally messy with bizarre refusal to excise bad law. I was not expecting this, but I think Arkansas is very manifestly the worst state we've discussed so far. Of course, we've only covered a handful, all of which are fairly gun-friendly, but I take deep issue with some of Arkansas's problems. For one, the state constitution and its court have made it devastatingly clear that the state right to arms is one born of law and order rather than a respect for your individual rights. The state's bizarre culture of dense regulatory spiderwebbing when it comes to the right to arms cannot be easily explained away when allegedly pro-gun members have been in control of the state for such a long period of time. The state treats certain firearms with deep suspicion, it invokes common law terminology just to give a contradictory statutory definition, and it has duplicative laws all over its code books. While the state may mean well, in my opinion, it's presently a fairly friendly minefield for the gun owner. I give it a C-. It can do better. Of course, with the states that's coming next, I think Arkansas might look pretty decent in comparison after we do the next one. Think I'm wrong? Did I miss anything? Be sure to let me know down in the comments. That's it for today, guys. Let me just say I really appreciate you watching and subscribing. It makes a huge difference, and it helps me keep going with this type of stuff. If you want to support me more than that, I've started up a Patreon and a Subscribe Star. There's benefits like patron-only content, a Discord, and surely there's going to be more. This kind of support will help enable me to make more content more regularly, something that I really desperately want to do. There's also a link to some new Fuddbusters apparel. It looks great. We've got stickers and, of course, the Magic ATF ball, which is going on holiday sale. Thank you all so much for watching to the end and for your support. I will see you next time, or if you join up on Patreon or Subscribestar, I'll see you on the Discord. Remember, the anti-side has been working long and hard, passing laws and trying to push more policies. Anything more than minimum compliance is self-regulation. Y'all take care. Thank you.